think we're now ready to move on to the Birches and Glassfield Road barn home.
Thank you, Chair. Good morning. Members will be aware of this site from their site visit and in respect of the previous application that was allowed on appeal. This application proposes an additional 4 pitches, the stationing of 4 caravans, day rooms, an additional hardstanding and reconfiguration of the existing pitch and stable block. Members have a very full report on this matter, and I'll now take you through the PowerPoint presentation, and you will have also seen some additional items on your late papers. The oil pipeline plan has been appended to that and the related objection on behalf of the pipeline owners, and I will update members shortly in respect of further comments that have been received. The first plan shows the red and blue line, obviously the blue line showing the land in the ownership of the applicant, and the red line showing the application site with the area of the previous appeal site. This slide shows what was allowed on appeal and shows the buildings and the location of those buildings. And this plan illustrates the proposed application. Part of it is in retrospect, part of it has not yet been commenced, showing the reconfigured appeal site. You'll see that the mobile has moved from the east of the plot to the north, and the day room has been rotated. The tourer has been moved to the eastern side of the plot, and there is a revised stable form. It's actually an L shape rather than the rectangular form previously. And the slide illustrates the position of the other plots of the mobile, showing the mobile homes that are proposed in purple, the utility day rooms in pink, and the touring caravans in red. It also shows the access drives onto the plot and the plot division and the landscaping that is in place and some additional landscaping, and the approximate position of the pipeline is shown. This slide illustrates the proposed day rooms that are part of the application. This is looking across from Glassfield Road towards the appeal stable building, which is the red roof that you can see in the picture, the reconfigured position of the mobile home, and the roof of plot 3 shown immediately adjacent to the green shed that you can see in the foreground. This is just a closer view of that one. This shows the entrance with the laurel hedging that's along the front of and the return displays, and the fences and gates. And you can see from looking into that the plot division that has occurred, or subdivision that's occurred within the site. And this is looking along Glassfield Road with Davies Lane behind you, where you can see the height of the established laurel hedging that has been planted on the site. And this is a view looking back across to the site from the Stanton Road, or the Stanton to Bardwell Road, where you can see the site and the visual prominence in the relatively flat landscape. And again, that's a closer view of it, and you can see the applicant's horses on the field, which is on the land that's marked blue on the plan. And again, this is a similar view taken from a slightly different angle on the road. And that's a view looking across from Davies, up the sort of Davies Lane, Stanton Road corner towards the site. That's just a plan to remind you where we've been looking from. Obviously the northern part of the site is where we're looking at from the Stanton and Bardwell Road, and Davies Lane is to the west of the plan that's before you now. This is a picture inside for the stable building, the reconfigured part of the site that was allowed on appeal, and this shows the stable building, and you'll note that there is a flue with smoke coming out of it. That building is currently being at least part occupied on the site as a residential unit. And you'll see the touring caravan and where the drive sweeps round, and the mobile home is immediately to opposite the stable building in the reconfigured form. This is another view looking across to that from one of the other plots, and you can see the reconfigured position of the mobile home, the stable building and the caravan and shed, and also leylandii hedging that has been put in as part of the plot subdivision. And this is a view of that same mobile home for that plot, looking across from a different angle and looking back towards Davies Lane direction. Again, just a plan to familiarise members again as to where we've been looking at with the different views and the planting that is along the frontage and within the plot subdivision. This is a view looking into one of the plots immediately adjacent to the stable building, and you'll see the touring caravan on that plot and the 5-bar gate that is at the end of that driveway where there is hardstanding laid, but the static van has not been, or mobile van has not been brought onto the site as yet, and you'll see also a shed building to the side of that, and obviously you've got the gates and walls that have been erected to create that plot as a separate plot within the site. This is the plot as you come into the entrance of the site, so as you come in it's immediately on your left and shows the access drive, the mobile home on the site. And this is just a different angle of that mobile home with the vehicles and the caravans that are present on site, and you can see the Leylandii hedging on the immediate right of that picture with the next plot and the caravan, the touring van on that plot. Again, that's just a closer view of that plot and the subdivision through the Leylandii hedging and the hedging that's on the boundary. That's a view towards the area where where there is an animal enclosure on the site. There are chickens in there, and since this photograph was taken, a field shelter has been placed immediately adjacent to that animal pen and is used in part with the chickens that are enclosed within the pen. This is a view as you get to the end of the access drive, so you've got the 2 plots on either side, and this is where the access drive turns to go into the appeal plot that is the subject of the reconfiguration. And again, that's just a view towards that appeal plot, and obviously the countryside beyond and the Stanton to Bardwell Road is beyond that. Again, that's another view just looking into the plot that's adjacent to the appeal site plot, which we've discussed previously. This is a view of the plot immediately as you enter the access drive on the right-hand side. You can see the access drive has been laid to that plot, the plot is fenced, and the caravan is on the site in that position, as you can see. And again, that's just to remind members of the position of the different plots and the appeal plot. This is again viewing the first plot on your right as you enter the site, and you'll also see that there is a shed on that site as well. Again, that's the plot that's immediately on the left as you enter the site, and again you can see the hedging that bounds the site. This is the plot that's the subject of the as you come into the site, and this is when the mobile home was being put onto the site. This is the one on the left-hand side, and you can see that one being placed on the site. So that's the one just inside, as I say, on the left-hand side, and you can see the blue of the static there. Members will be aware, as your colleagues said, that the development management policies have now been adopted, and these are referred to in the committee report, and they are therefore the relevant policies for consideration. As I've already explained, members do have a full report. The application has not been accompanied by a Phase 1 contamination report, neither has there been any need argument advanced by the applicant or their agent. By way of an update and to correct a typographical error, the travel and liaison officer referred to in the late papers refers to a Mrs. Oakley for the welfare visit, not Ms. Oakley. Ms. Oakley is the applicant and Mrs. Oakley is neither the applicant or the owner of the site. Also, by way of an informative only, Fisher German, acting for the pipeline owners, which is the government pipeline storage system, have maintained their objection and expressed concern about the proposal on a number of fronts, and there appears to be no protection pads in place to deal with the increased vehicular loading over the pipeline, and they strongly recommend no further vehicle movement above the pipeline, as the unsupervised and unconsented driveway is not in accordance with their safety requirements. Their objection is maintained, and they've expressed a view that they will not grant the necessary consents under Section 16 of the Land Powers Defence Act 1958, but that is purely just as an update for members, as an informative. The recommendation is one of refusal and remains as set out in your papers. Thank you.
information will be restored. Good. Right, we have a number of public speakers on this one. We have Mr. Tony Stokes. We have Mr. Peter Sanderson, who is the chairman of Barnwell Parish Council. Kelvin MacDonald, who is the chairman of Stanton Parish Council. And the ward member, or one of the ward members, Councillor Paul Wade. I figure as the other ward member, but I do not wish to address committee from where I'm sat at the moment. I think it might be considered as leading or something, so I should be saying nothing. As we did last time with this application, because it sits very close to the Stanton boundary but is in Barnwell, we're running both parish councils, which means we run 6-minute slots for anybody else. So we will kick off with Mr. Tony Stokes, who is an objector. You have 6 minutes, sir, all on your own.
Thank you, Chairman. We are objecting to a planning application that 2 years ago the applicant, through her agent, said would never happen. A view that several officers agreed with at the time. Since the granting of permission for one pitch by the inspector, we have seen a willful disregard of the conditions imposed by the inspector. Buildings and vehicles are on the site that are not permitted, including apparently commercial trucks. The application does not state accurate facts. Has work started? No. How many vehicles now? None. You have seen from the picture, seen for yourselves that extra buildings, walls, and up to 13 vehicles, mainly vans and trucks, and not, as the agent's latest statement, mainly cars. With 8 movements per pitch, when a vehicle goes out, it comes back. With 5 pitches, the total is 40. So is that actually 80 trips excuse me, on the road? And are they vans and trucks, not cars? I feel that this traffic will be concentrated mainly on 2 of the roads and not equally spread between the 4. They will take the road of convenience to where they want to go. I therefore think that the highways report is unsound on the type of vehicles and the type of journeys. Should a real need, as opposed to a want, have existed, the applicant could have followed the correct procedure or stated this on the retrospective application or met the liaison officer at the right time. None of this was done because a genuine need does not exist, and therefore that statement should be given little, if any, weight. The pipeline company have lodged an objection and pointed out the consequences if ignored, which includes anyone who is complicit. And would that apply to the authorities if unsupervised or uncontrolled development takes place? The occupied stables have been walled, has been laid out to a garden, it's been fenced, it has garden lights, and clearly is intended for permanent use. Paragraph 39 of the Rural Vision says there are sufficient permissions, 5 pitches, to meet the needs for the next 5 years. There is no demonstrable need for a further 4 pitches on this site in Borough. Borough has significantly increased its housing in the past 18 months. When these are fully occupied, the village population would have increased more during that time than the previous 10 years. The number does not include nearby places such as Birmingham or the 200 agreed but unbuilt properties in Exworth and Stanton, all needing the same schools and NH services. Enough is enough. Further development in Borough is not needed or not sustainable. Previously, in the inspector's report, she stated that one pitch causes moderate harm to the character and appearance of the landscape because of its location and distance from which it is visible. I suggest that 5 times moderate is unacceptable harm. Planning policy for travel sites states that local planning authorities should strictly limit new traveller sites developments in open countryside. That is away from existing settlements or outside areas allocated in the development plan, which this clearly is. 170 of the village residents attended our public meeting. They signed the objections and support the officers' recommendations, and we urge this committee to reject this proposal. Thank you.
Thank you, Mr. Stokes. Now we have Councillor Sanderson, Chairman of the Borough Parish Council. 3 minutes, sir.
Thank you, Chairman. Borough Parish Council does not object to travellers, but strongly objects to this application. We wish to see the countryside preserved. We want the planning process observed and not held hostage to fortune. There are traffic concerns. Firstly, we are here because the Borough Council decided to seek an injunction against unplanned development as the applicant had ignored the conditions granted with planning approval for one pitch. Buildings have been built in the wrong place and orientation, but worse, they have constructed more buildings. The planning process is meant to be fair. If someone secured planning permission for one house facing north, everyone would be horrified if they built a house facing south, as well as a second home. The abuse of process makes enforcement action essential. We ask that the law is applied equally to everyone and everywhere. Your officer says the proposal would cause unacceptable harm in relation to the criteria in policies CS6, 3 and 2. In short, the development of more than one pitch will cause an urbanisation of a rural setting. Frankly, it will be a carbuncle on the landscape. We objected in similar terms to the initial proposal, an appeal the inspector made of the need for one pitch outweighing on balance other concerns. It was a close decision. This proposal for 5 pitches will more than outweigh that balance. Regarding traffic, the applicant has failed to provide any evidence to support the application. You should refuse this traffic generative proposal in a landscape with very narrow roads for that reason alone. The applicant has failed to identify any need for the sites. The note from the traveller service makes much of the traveller's need to live there. This is nonsense. Before moving illegally onto the site, the people lived somewhere. Presumably, they needed to live there. Now they've decided they want to live on this site. Want is very different from need. Many people want to live in beauty spots or in expensive properties in Bury's medieval grid, but their desires are not needs. Nobody needs to live in a specific location. We would all be subject to anarchy, was it so? The applicant has failed to identify any need across the district. Indeed, your officers have demonstrated that the need for travellers' pitches has been met. To summarise, the applicant has built a development in contravention of their own application and in contravention of the appealed inspector's decision. We must ensure that the planning process remains fair to all, fair to the applicant and fair to objectors. Overwhelmingly, this application must be rejected on its merits and in terms of planning law to preserve the credibility of your own decisions. The planning system is therefore to protect everyone. We urge you to reject the application. Thank you, Chairman.
Thank you, Councillor Sanderson. Right. Councillor Kelvin McDonald, Chairman, Stanton Parish Council.
Thank you, Chairman. Stanton Parish Council objects to the application in front of you. Stanton objected strongly to the last planning application for the travellers' pitch on the site, on one site. Our reasons for objecting to that application are multiplied with this urbanisation application in front of you today. The last application was approved following appeal. Importantly, in making that decision, the inspector cited balance in making the decision, weighing the impact on the countryside, contravention of your council's own policy versus the provision of one pitch. With the number of pitches in this application multiplying the impact on the countryside by 5 times, any decision now, on balance, weighing the impact on the countryside, must be rejected. St Edmundsbury District Council has established that it's met its need for traveller sites. Furthermore, a need for a traveller site is not necessarily location specific. We echo Borough Parish Council's view that want is not the same as need. Just because we want to live next to our relatives or in a pretty spot doesn't mean we should be given planning permission. This rule must follow for all. Furthermore, this proposal, if accepted, will codify a position where an applicant can ignore their planning permission, setting a dangerous precedent for the district. It must be stressed that not only has the applicant constructed buildings they haven't got permission for, they haven't even placed the ones they have permission for correctly. Can you, as councillors, really do anything other than reject this application? An application that has only put in following judicial requirement. Frankly, the impact on the countryside and lack of due process are sufficient to reject this application, but we can go on. The application has submitted an inaccurate, the applicant has submitted an inaccurate application. They claim they have not started construction of the buildings and are seeking permission, for yet they have only submitted the application because they have been called to building them. They have not submitted a traffic statement. One is required. These windy country roads in which the site is situated will suffer due to the impact of the equivalent of a car lot's worth of cars. Returning to need, the applicant has failed to submit any evidence to support the construction of this illegal settlement. In summary, I would think this is one of the easiest applications to reject you have ever seen. The application has been made under duress in order to seek your approval or rejection of this illegal development following injunction. The application has errors. The application fails to make need, case or provide any traffic information. The application, if approved, will destroy countryside in contravention of the council's own policies. I urge you to reject this application and simply apply planning law as it is meant to be applied.
Thank you. Now we have Councillor Paul Wade, who is the Borough Council ward member. 6 minutes, if you read them.
Thank you, Mr. Chairman. Thank you. Sorry, technical glitch. Thank you, Mr. Chairman. I sit before you today to make representation against this application on behalf of local residents and in respect of the principles of fairness. This application should be refused as recommended by officers because it constitutes inappropriate development on a number of different levels. Much of this application is retrospective, and the urbanising effect of this development dramatically alters the openness, character and appearance of the area. It is an alien, intrusive urbanisation of the countryside which has been compounded by the introduction of non-native plants and hedges in contravention of planning conditions placed on the original application. The applicant has failed to provide the requested information on vehicular access and has refused to undertake a Stage 1 land contamination report. There has not been a statement of needs submitted in support of this application, and this Council's Vision 2031 document, which I must stress has been the subject of much scrutiny, identifies sufficient properties to meet the need for Gypsy and travellers up until 2020. The applicant's failure to submit a statement of need suggests to me that this application is about want rather than need. We all want things we can't have, and previous applications by local residents for development in this very area have been rejected as inappropriate in open countryside. Policy C of the PPTS insists on fair and equal treatment for travellers while respecting the interests of the settled community. Approving this application would not be fair and equal. It would be an unfair and unequal acceptance of bias against the settled community and a failure by this council to protect the environment from unsustainable, harmful development. This application is at odds with policies DM1, DM2, DM5, DM13, DM14 and DM27. It is also contrary to policies CS2, CS3, CS6, Policy 8 of the PPTS and paragraph 121 of the MPPF. No one, irrespective of colour, creed, religion or ethnicity, should be allowed to ride roughshod over planning policy or process. Therefore, in light of this application's disharmony with planning policy and the detrimental impact it would have on the area, I urge members of this committee to refuse this application. Thank you.
Thank you, Councillor Wade. Right. Committee, most of you, I think, saw the site. And so over to you, Councillor Rushton.
Thank you, Chairman. I didn't visit the site last week, but I have been there before on a site visit, so I do know the site. Having listened to everything that we've heard this morning, I have no alternative but to move refusal.
Is that seconded, Councillor Warby? Yeah. Okay. Right, we now are speaking on refusal. Councillor White.
Thank you, Chairman. I'm very happy having just missed the seconding of this application to refuse it. I would support that. It would be hard, having been on the site visit, it would be really hard to come up with a plan that is more intrusive in its nature into the countryside and more alien to the open landscape that surrounds this particular site. Everything about it, from what you saw of the brick pillars that support some iron gates to the alien hedging. We have worked hard to try and get away from Leylandii hedging in the open countryside now. It's not conducive to the Suffolk native species. So absolutely everything about this application shrieks an intrusion into the countryside, and we've heard all the arguments, the policies that it fails to support, and therefore I'm more than happy to go along with refusal of this application, Chairman.
Thank you, Councillor White. Councillor Stevens.
Thank you, Chairman. We listened at the previous application to the arguments about open countryside, and our decision to refuse that application was overridden by the inspector. And my very worst fears have been now established that this creeping urbanisation of the countryside as a result of the previous application and this new one have come forward. I've listened carefully to the concerns of the local residents, and I agree in their fears. I mean, we must send a robust message to the travelling community that they must abide by the planning rules that we all have to respect. And I would recommend robust enforcement procedures to remove any unauthorised structures from this original application and to refuse this present one.
Thank you, Councillor Stevens. Councillor Oliver, did you indicate otherwise?
Yes, Chairman, thank you very much. This is not a part of the world that I normally frequent, but I have been there on 2 occasions on the site visit with this committee, and the thing that struck me immediately was the intrusive hedging around this site, put there ostensibly to screen it, but in fact it screams that this is something here that shouldn't be here, and it just is a complete complete out of place in the middle of this bit of open countryside. I mean, it is a very sparse, flat, level piece of land, farmland all round, and in the middle of it is this enormous, fierce, aggressive green hedge, completely inappropriate. And so, having said that, I don't think I need to say anything about what is inside the hedge, as that's been adequately described by other speakers. But I think the whole concept is just awful, and it shouldn't be permitted in any form. Thank you.
Thank you, Councillor Oliver. Councillor Marks.
Thank you, Chairman. Quite frankly, the list of policies which this development is contrary to is extensive and unbelievable. I mean, how on earth this has ever happened is scarcely credible. And because of this breach of planning regulations and our policies, then there's no way in which this committee can sustain this development.
Thank you, Councillor Marks. Do you want to comment on Councillor Stevens' enforcement? Mr. Beaton? Enforcement?
I'll just draw members' attention to the paragraphs, I think 16 to 20 in the report, which set out a little bit of the enforcement context. This obviously is partially retrospective. The reason it's not, I suspect, entirely retrospective is because of the swift and relatively robust action that the authority took at that stage, which was to seek immediate injunctive relief in the High Court to prevent any further breaches of planning control occurring on the site at the stage that we were first aware of the site. Initially, as you see from the report, it was the sighting of additional touring caravans that was the nature of the breach. Now, in discussions with the travel liaison, so at that stage, we felt that a watch and brief was more appropriate because the indications then that it would be a transient breach and that the caravans would then leave the site in due course. That was the anticipation at that stage, obviously incorrect with the benefit of hindsight. As soon as we were aware in late November 2014 that there were additional physical structures being presented on site, the hardstandings, the static caravan on the southwest part of the site, that was when we realised that this was clearly escalating in a much swifter fashion than we had anticipated. That the most obvious solution at that stage was to approach the High Court to seek an injunction which prevented both any further breaches of planning control and also restricted the existing breaches of planning control, albeit the court subsequently agreed to hold that in abeyance pending the determination of this planning application. So as we'll see from the report, there are a further 14 days beyond today's date in accordance with the terms of the injunction that requires resolution of all the existing breaches of planning control. Any failure to do that will be a committal process in theory as a breach of the injunction. Of course, as I've also said, or as has also been said in the report, it is open to the defendants to approach the High Court if they wish to agree or to seek an extension of the terms of the order. That's obviously a matter that the authorities previously resisted and I would suggest would do so again. Again, the decision there would be with the High Court judge to decide on that part. Thank you.
Right, we have it proposed and seconded for refusal with the reasons on page 33 and 34. All those in favour, please show. Thank you. So there can be none against. Oh, over to you, Joe.
That is unanimous for refusal